Hello and welcome to the Minimum Competence episode for Thursday, January 29th, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, Alex Pretti murder review, a looming judiciary shutdown, Google's $135 million data lawsuit settlement, and a teacher's failed First Amendment appeal. Let's remember, every act of rebellion expresses a nostalgia for innocence and an appeal to the essence of being. And read today's legal news. On this day in legal history, January 29th, 2002, President George W. Bush delivered his first State of the Union address after the September 11th attacks, a speech that would shape U.S. legal and foreign policy for years and decades to come. During the address, Bush coined the term axis of evil to describe Iran, Iraq, and North Korea, alleging these nations were actively pursuing weapons of mass destruction and supporting terrorism. The speech marked a significant rhetorical shift in the U.S. posture toward preemptive military action and helped solidify a legal framework for broad executive authority in the name of national security. Citing the 2001 Authorization for Use of Military Force, or AUMF, the Bush administration would go on to justify military interventions without new congressional declarations of war. The axis of evil framing played a critical role in building public and political support for the 2003 invasion of Iraq. Though the legal justification centered on Iraq's supposed weapons programs and ties to terrorism, both claims were later discredited, leading to intense scrutiny of the legal rationale behind the war. Domestically, the period following the speech saw rapid expansion of executive power, new surveillance authorities, and detention practices that raised constitutional concerns. Internationally, the speech signaled a departure from multilateral norms and toward unilateral action under the banner of American security interests. The legal legacy of the address continues to reverberate in debates over presidential war powers and the limits of the AUMF. Critics argue the speech set a precedent for indefinite military engagement without sufficient congressional oversight. Supporters contend it met the urgency of a new kind of threat in the post-9/11 world. Regardless of viewpoint, the 2002 State of the Union redefined the intersection of law, war, and foreign policy in the 21st century. A preliminary review by U.S. Customs and Border Protection, or CBP, into the murder of Alex Pretti by federal immigration agents in Minneapolis did not state that Pretti brandished a firearm, contradicting earlier claims by Trump officials. Pretti, a 37-year-old ICU nurse, was shot after reportedly refusing to move from the street when ordered by a customs officer. Initial official statements described Pretti as an armed threat with the Department of Homeland Security, noting he had a handgun, though it was holstered, and Trump aide Stephen Miller labeling him a, quote, domestic terrorist without any evidence whatsoever. However, video footage from the scene challenged these claims, showing an agent removing a holstered weapon from Pretti's waist before the shooting. The CBP review, based on body camera footage and internal documents, said officers attempted to move Pretti and a woman from the street and used pepper spray when they didn't comply. A struggle followed, during which a Border Patrol agent shouted, "He's got a gun," before both agents opened fire. The review, which is standard protocol, was shared with lawmakers but emphasized it contained no final conclusions. The identities and experience levels of the involved officers, particularly regarding urban crowd control, remain undisclosed. The incident has sparked national controversy and prompted a more restrained response from Trump in its aftermath. The U.S. federal judiciary may only be able to continue full-paid operations through February 4th if Congress does not pass funding legislation in time to avert yet another partial government shutdown. Judge Robert Conrad, who oversees the Administrative Office of the U.S. Courts, issued a memo warning of the looming shortfall, stating that while courts will remain open on February 2nd, they would quickly exhaust available funds by February 4th. The uncertainty comes amid a broader funding standoff in Congress, where a six-bill package, including money for defense, housing, transportation, and a $9.2 billion judiciary allocation, is stalled. A key point of contention is the funding of the Department of Homeland Security, especially following the fatal shooting of U.S. citizen Alex Pretti by immigration officers. Senate Democrats are now refusing to approve DHS funding without reforms, throwing into doubt whether the broader package can pass. Although the bills had passed the Republican-controlled House and previously seemed poised for Senate approval, the Pretti incident, that is to say, the Pretti murder by DHS agents, has triggered renewed partisan gridlock. If no agreement is reached, the shutdown could affect the judiciary much sooner than the previous lapse in 2025, when courts operated for over 2 weeks before curtailing services. The current funding crisis threatens court staffing, case management, and broader access to justice. The memo underscores the fragile position of the courts in a prolonged budget standoff, with potential furloughs and suspended operations looming if a deal is not struck. Google has agreed to pay $135 million to settle a proposed class action lawsuit accusing it of collecting Android users' cellular data without their consent. The settlement, filed in federal court in San Jose, California, still needs judicial approval. The lawsuit claimed that even when users closed Google apps, disabled location sharing, or locked their devices, Google continued to gather mobile data, which users had paid for through their carriers. Plaintiffs allege this behavior amounted to conversion, a legal term referring to the unauthorized taking of someone's property for one's own use. Though Google denied any wrongdoing, it agreed to stop transferring data without user consent during Android device setup. The company will also update its Google Play terms to clearly disclose data transfers and give users a simpler option to disable them. The case covers Android users dating back to November 12th of 2017. If approved, users could receive up to $100 each from the settlement fund. Plaintiffs' attorneys described the agreement as the largest known payout in a conversion case, and they may seek nearly $40 million in legal fees. A trial had been set for August of this year before the settlement was reached. Google has not commented on the resolution. A Christian substitute teacher, Kimberly Ann Polk, has lost her attempt to revive First Amendment claims against Maryland's Montgomery County Public Schools, or MCPS, after refusing to use transgender students' pronouns. The Fourth Circuit Court of Appeals upheld a lower court's decision, finding Polk unlikely to succeed on claims that the district's pronoun policy violated her free speech and religious freedom rights. The court ruled she failed to show any evidence of religious hostility from the school board and did not meet the legal threshold to proceed with her constitutional claims. Polk argued that MCPS's policy, which requires staff to use names and pronouns aligned with students' gender identities and bars disclosing those identities to unsupportive parents, conflicted with her belief that gender is fixed at birth. While the court dismissed her constitutional claims, it allowed her separate Title VII claim for religious accommodation to proceed. This claim argues that MCPS violated federal civil rights law by not making space for her religious beliefs in its employment practices. The decision was split, with Judge J. Harvey Wilkinson dissenting. He called the school policy a, quote, gross assault upon the First Amendment and argued Polk had a valid free speech claim. The case reflects ongoing national legal tensions between employee religious rights and school policies supporting LGBTQ+ students. Notably, another federal appeals court had previously sided with a teacher in a similar dispute, signaling a potential circuit split. And you all know what that means. Up it will go to the Supreme Court. And we all know what that means. With that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, disobedience is the true foundation of liberty.